Defenses in criminal cases fall into two separate and distinct categories. There are defenses that negate a specific element of the offense that the district attorney has to prove. And then there are defenses that admit the elements of the charge in a crime, but provide a legal justification for committing that crime. Here's an example of both. So in the case of a DUI charge, the district attorney would have to prove that a person was driving a motor vehicle while under the influence of alcohol, drugs, or some combination of the two. So a transverse defense to that charge would be evidence that a person wasn't actually driving. So a situation where, they're asleep in the backseat of their car, keys are nowhere near the ignition, something like that would go to negate that element of driving. A justification or an affirmative defense provides legal justification for committing a crime. So let's think of that same situation, but it could be somebody is driving under the influence of alcohol because their wife went into labor and they have to get to the hospital. She's in an immense amount of pain. And there's no Ubers or taxis or anybody else available to drive them to the hospital. 911 response time was too long, something like that. Well, our law would say that even though you committed a crime, we're going to allow you to argue that you had a justification for doing so because it was worth it to commit that crime to prevent a worse thing from happening, which would be, somebody potentially falling ill or becoming severely injured or deceased as a result of a pregnancy. Now, there is a category of affirmative defense that's called, in Colorado, it's known as the choice of evils defense. And other states call it the defense of necessity. But what the choice of evils defense does is, just like our last example, it authorizes somebody to commit a crime in order to prevent a worse thing from happening. So I'll give you the exact definition of that choice of evils defense. That defense states that unless it's inconsistent with a couple of other statutory sections, which define the justifiable use of physical force or some other provision of law, so self-defense, etc., conduct which would otherwise constitute an offense is justifiable and not criminal when it is necessary as an emergency measure to avoid an imminent public or private injury which is about to occur by reason of a situation that was occasioned or developed through no conduct of the defendant and which is of sufficient gravity that, according to the ordinary standards of intelligence and morality, the desirability and the urgency of avoiding the injury clearly outweighs the desirability of avoiding the injury sought to be prevented by the statute defining the offense in issue. So there's a couple of things that go into that defense of choice of evils. One, the issue which you're seeking to avoid has to be of a significant enough nature to justify the law violation. So for example, you're not allowed to kill somebody to avoid having them steal something from you. It also has to involve the imminent use or the imminent act of some kind of unlawful or dangerous activity. So imminent means something that's going to happen immediately, is happening, or is happening in the very near future. Then the statute also requires that the need to invoke this choice of evils defense, so the need to commit this act which would otherwise be a crime, cannot be started or occasioned or resulted from the defendant's own conduct. So for example, you can't put yourself in a situation, like a dangerous situation or something for that example, that requires you to then break a law and then use that as a justification. Here's an example of a situation where the choice of evils defense comes up a lot. If somebody is a felon, so somebody's been convicted of a felony, they're not allowed to have a firearm, but they are carrying a firearm in order to protect themselves, their property, or their loved one, can you use the choice of evils defense in that situation? What the law says is that you can, but again, it's got to be in response to an imminent act or an imminent situation which was not occasioned by your own conduct, and there were no other available alternative means to protect yourself, your loved one, your family, or your property. It's not a situation where you could violate the felon with a gun statute. In Colorado, we call that the possession of a weapon by a previous offender statute. You can't violate that statute just because you have a general feel that the world is a dangerous place. You have to establish that there's an imminent likelihood of somebody using unlawful force against you or your family or your loved ones or something like that. So, for example, if you were in a convenience store and somebody was robbing the convenience store and you stopped the robbery and held them at gunpoint until the police arrived, well, then that would qualify as a reason to invoke this affirmative defense. You'd be able to show that there wasn't time for you to call the police to seek their response or aid, that this was a serious situation that merited that law violation, right? Avoiding robbery certainly justifies holding on to a firearm for a brief period of time, even though you're not allowed to. And there was no other alternative available means to address that, and you didn't cause that person to be robbing the convenience store in the first place. So those are situations that may justify the endorsement of that affirmative defense. Now, what's unique about affirmative defense is that affirmative defenses have to be endorsed in advance of trial. So you have to provide an endorsement of your affirmative defenses to the district attorney 35 days before trial in Colorado. That's because the district attorney is entitled to be made aware of these defenses and then to come up with any rebuttal evidence or investigate them and to have time to do that. Transverse defenses do not require that. It's the district attorney's already on notice that you're going to be trying to knock out the elements of the charge they've charged your client with. The last thing about these choice of evil defenses is that the judge acts as an initial barrier to the endorsement of this defense through typically a process of a pretrial hearing where the judge will hear what evidence the defense anticipates will come out at trial through what's called an offer of proof, where the defense comes in and says, this is the evidence that we intend to present at trial. This is why we think it meets the elements of this affirmative defense. And the judge is going to have to make a decision that there is at least a scintilla, which means the bare minimum amount of evidence for each of the elements of that affirmative defense to justify the endorsement of that defense at trial, which means to allow the defense team to argue that defense at trial and to present that to a jury. So those are all the different steps that you go through to get the affirmative defense of choice of evils endorsed and presented at trial to a jury, challenging one evil against a worse one.